And the Coal Rice California Manufacturers and Technology Association also opposed.
Thank you. Anyone else wishing to speak or to add on in opposition to the legislation? Okay, hearing and seeing none, at this time we'll bring it to the committee. Members of the committee, any questions or comments for the author? Vice Chair Harper.
Thank you very much, Mr. Chairman. Just in concern with the potential increase for red tape for employers, as well as construction here within the state of California. Two things that we greatly need more of. I'm just always concerned about the increased burdens in terms of taxation, regulatory environment. And with that, I'll be respectfully voting no.
Thank you very much. Anyone else wishing to make a question or comment? Assemblymember Chu.
Just out of curiosity, how much cost will we added to this process?
All we're really talking about is a simple notice as part of the variance application to those affected employees who are currently not part of the notice requirement, to give them a notice, which means some sort of a letter, perhaps, or something in the application itself that says these employees have been notified that there is a variance application in place. That's nothing more than a line or two on the application. Yeah.
Or phone call.
It could be a stamp. You're right. You're right.
All right, great. With that, I'd be happy to move this bill forward.
All right, thank you. The bill's been moved and seconded. Any other questions or comments from members of the committee? Hearing and seeing none, Mr. Lowe, would you like to close?
I'll just, I very much appreciate the comments of Vice Chair Harper, and certainly took that into consideration when looking at this as well, and I respectfully ask for your aye vote.
Thank you, Mr. Lowe, for bringing this measure forward. I think it's common sense. I think when we consider the serious concerns that OSHA is looking at, we need to make sure that all stakeholders are at the table, and those that are working in the process of putting this equipment together, making sure that the safety of the equipment is effective. We need to make sure that, again, that the employees are present at the table. They are those that are going to be most directly affected by decisions made here, and the due process is something that's critically necessary. So with that, Madam Secretary, please call the roll.
Motion is due pass as amended to appropriations. Hernandez?
Aye.
Hernandez, aye. Harper? No. Harper, no. Chu?
Aye.
Chu, aye. Lowe?
Aye.
Lowe, aye. McCarty? Aye. McCarty, aye. Patterson? No. Patterson, no. Thurman? That bill is out.
Bill is out. Congratulations. Mr. Lowe, if it's okay, I'd like to have Ms. Campos come. Since she's here, I know she's got busyness all over the building, like most of us.
He's a committee member, so he'll have to stay here regardless, right?
He's got to stay. He's got to stay, or else we don't have quorum. All right.
Thank you.
Assemblywoman Campos, welcome. Whenever you're ready, you're welcome to commence.
Thank you, Mr. Chair and members of the committee. I would like to start by offering committee amendments to strike out the General Counsel provision from AB 561. You should have received a copy of the mock-up of the amendments. The bill I am presenting is AB 561, a bill that would help expedite the process for farm workers to recover the fair wages they are rightfully owed. AB in 1989, farm workers from the Ace Tomato Company voted to have the United Farm Workers represent them. However, Ace Tomato refused to negotiate new employment terms with the United Farm Workers. And because of this, and the challenges at the Agricultural Labor Relations Board, 600 farm workers have not received any back pay or benefits to this day. These type of cases cannot be the standard. While AB 561 won't help the Ace Tomato workers, it will help prevent future Ace Tomato cases. It will do this by establishing a mechanism for organized farm workers to recover back wages and benefits in a fair and speedy manner. And this is how it would happen. First, it would require employers to post a bond in the amount decided by the Agricultural Labor Relations Board before they start the appeal process. That way, the money would be immediately available for the workers if the employer loses the appeal. Second, it would require the ALRB to come to a decision within 1 year of the ALRB finding liability for benefits. This is an important bill, and I would hope that you could see the benefits, and I'm going to turn it over to the witnesses to testify.
Thank you very much. Your first witness, please.
Good afternoon, Chair Hernandez and members of the committee. My name is Mario Martinez. I'm General Counsel for the United Farm Workers. Here with me today is an Ace Tomato worker, Mr. Hernan Cortez, who has been fighting for decades now for benefits and wages at that company. It is an honor to be here today with Assembly Member Nora Campos, who is a farm worker champion in support of AB 561. Farm workers are a simple people. They are humble, they work hard, they break their backs, their hands, and their bodies, feeding our state and our nation. They are immigrants. When the Agricultural Labor Relations Act was passed, it was meant to protect farm workers. As Ms. Campos stated, in 1989, hundreds of tomato workers at Ace Tomato and another company nearby voted for the union. In 1992, the ALRB certified the victory of that election, but the company at the outset illegally refused to bargain with the UFW. Yet 23 years later, these farm workers are still waiting for the money owed to them through back pay, or technically what's called the make-whole remedy under the ALRA. What a worker would have made had the employer complied with the law by negotiating in good faith with the union. The ALRA is celebrating 40 years this year. So over half the time the ALRA has been in existence, these farm workers have been waiting for justice. Within that same time, we've had 5 governors, and not one administration or their appointees have been able to resolve this very simple issue. Ace Tomato is one case, but not the only case exemplifying unacceptable agency delay. 5 years ago now, I testified at a joint hearing held by the Assembly Labor and Employment Committee and the Budget Subcommittee, specifically on agency delay in the Ace Tomato and San Joaquin Tomato make-whole cases. And the committee, both committees, were given assurances that these cases would be promptly resolved. That was 5 years ago. Yet, the farm workers from these farms are still waiting for the law to work for them. We support the committee amendments to keep the authority of calculating back pay and make-whole as under current practice, and AB 561 calls for the ALRB to use this authority and come to a final compliance decision within 1 year of the time that the employer is found to have violated the law. You, as the legislature, are required to pass a state budget in less than 1 year. We believe 1 year is sufficient time for the ALRB to calculate and decide how much money farm workers are owed when an employer violates the law. In addition, the bill requires an employer who exercises its right to appeal to post a bond in the amount of the economic value determined, again, by the ALRB. This is not unprecedented. First, the Labor Code already requires an employer who appeals a decision of the Labor Commissioner to post a bond as a condition of filing an appeal. Second, a separate provision in the Labor Code requires employers to post even higher bonds as a condition of appealing wage awards won by garment workers, many of whom are immigrant women. This bill is reasonable given the unconscionable delay that has plagued our state agencies. We ask for your aye vote. Thank you.
Thank you very much. Your next witness.
Hola, buenas tardes. Mi nombre es Hernán Pérez.
Good afternoon. My name is Hernan Perez.
Y yo soy un trabajador de la Ace Tomato. Trabajé por 25 años.
I am a farm worker. I have worked with Ace Tomato for 25 years now.
Y nosotros por eso le estamos pidiendo aquí a los asambleístas que nos apoyen en esta propuesta, porque pues ya estamos un poco cansados de estar esperando mucho tiempo. Gracias.
We are here today asking for your support. We've been waiting for a long time. We're getting tired. Thank you for your time.
Thank you. Any other witnesses in support? Okay, hearing and seeing none. Anyone wishing to speak in opposition, please come forward at this time. Welcome, whenever you're ready.
Mr. Chairman, members of the committee, Louis Brown on behalf of a number of agricultural organizations, the California Fresh Fruit Association, California Association of Nurseries and Garden Centers, California Cotton Ginners and Growers Association, California Citrus Mutual, and a couple more somewhere in there. The analysis does include all of them. I'd like to start by commending the committee staff for the comprehensive analysis and background on this. It's very well done and very illustrative of the law, the duties and responsibilities of the board. I'd also like to say that on behalf of our clients, the issue of Ace Tomato is the workers are correct. 19 years is too long. And I think that if you were to call the current chairman of the Labor Relations Board, he would agree with the same. And in fact, the new chairman, recently confirmed by the Senate, has started to impose and create some changes, some regulatory changes in a number of different processes at the ALRB to ensure that justice is delivered in a more expeditious fashion. We don't claim to have a position on the issue of the one-year timeline. I'm not certain that that's really a concern for us. I think that's more a concern of the overall process of the ALRB and the people that go before it. Our concern is with the requirement of the bond for anyone who seeks an appeal, an employer who seeks an appeal. It's correct, as the analysis states, that the Labor Code does require a bond for, under Labor Code Section 98.2. The difference between that Labor Code section and the ALRA is that in the Labor Code section, once that appeal is sought, that the courts look at that appeal on a de novo basis, meaning that they see it as a clean slate. They don't take into account the ALJ discussions. They don't take into account the previous proceedings. It's a clean slate. They come forward. So when that section of the law was created, it was created to be a deterrent for unscrupulous employers just to simply to use that appeal process as a stall tactic, because they knew that once the court looked at that as a de novo status, it created more time. It's not that way under the ALRA. Under the ALRA is fashioned after the NLRA. And there are court cases that go back from the beginning of the NLRA that makes it clear that in an appeal of these types of actions, the courts are required to take into account the previous proceedings and findings of the NLRB and the ALRB. So there's not that same incentive to simply appeal for a non-meritorious action because you're going to get a clean slate with the courts. The courts are actually going to see the award, the courts are going to see the decision, they're going to see the testimony, they're going to see all the evidence that was presented to the ALRB that led them to that decision. So we believe that the requirement of a bond in this type of situation will only serve to deny due process rights for small employers that may not have the means to simply acquire the type of bond that may be required. There may be some situations where that number can't accurately be determined. So what if the bond, the ALRB actually determines a bond that's ultimately set higher of what the final decision might be? Again, that could be enough to deter an employer from their due process rights of actually filing an appeal. So it's on the basis primarily of the requirement of that bond that we oppose the bill and will be asking for a no vote today. Thank you.
Thank you. Next witness.
Good afternoon. Matthew Allen, Western. Good afternoon, Matthew Allen, Western Growers Association. Mr. Brown stated it very well, so I won't elaborate any further, but we are opposed to the bill.
Thank you very much. Next witness.
Brian Little with California Farm Bureau Federation. For all the reasons stated by Mr. Brown and Mr. Allen, we also are opposed. Thank you.
Thank you. We're moving to add-ons now.
Margot Parks on behalf of Family Winemakers of California in opposition for all of the reasons stated.
Thank you.
Valerie Nera for the California Chamber of Commerce, also in opposition.
Thank you very much. Anyone else wishing to add on in opposition? Okay, hearing and seeing none, we'll bring it to the committee. Members of the committee, any questions or comments for the author? Assemblymember Patterson.
Thank you.
Of course.
I do want to, first of all, deal with the due process question that was raised here earlier. It seems like it does deny due process to employers by requiring them to put up a bond before they are even able to appeal an ALRB decision. Do you have a response to what this appears, at least to me, to seem as though they are being forced to pay money to pursue a common legal action while other parties in cases do not have to pay this money? Having to post this bond essentially considers that employer in that situation is guilty until proven innocent. And so I'd like to, first of all, explore the necessity for the bond prior to the final adjudication, including the opportunity to go to court to get to a final determination of whether or not this entity is required to compensate. They may very well have, in that second opportunity in the courts, the ability to, as one of these other individuals said, in a clean slate look, actually be able to demonstrate that they did no wrong.
Mr. Patterson, thank you for the question, and I think that we read things a little different and we see it a little different. I hear your concern. It's a bond, and I heard Mr. Brown's explanation as well. We do not believe that asking for a bond that would secure the amount that is to be determined by the board would set that particular situation that you described. But I'm going to have Mario explain it to you from a legal perspective so that you and your colleagues will hear the reasoning on why we believe that this is important to be part of the bill. One of the reasons that it is part of the bill is because we do not want what has happened in the past with ACE to be another situation that happens where they don't have the ability after the board, and I understand that the board has changed and there are different procedures that will happen, but we have not seen that yet, and farm workers have not seen that. And we wouldn't be bringing this forward if we did not believe there needed to be certain policies and laws put in place so that justice is done for individuals who have earned their wages and have not been able to receive their wages. So I'm going to turn it over to Mauro for the technical.
Thank you, Mr. Patterson, for the question. Actually, the same argument about infringing due process was made when Labor Code 98.2 and Labor Code 2673.1 were passed. Those are both Labor Code provisions requiring the posting of a bond as a condition of filing an appeal in wage cases. And in fact, what the Constitution requires is a hearing where the employer or the party affected has a full right to present his or her case, to present witnesses, to present evidence. The ALRB's procedure does far more under its statute than even the Labor Commissioner, because the employer actually, under the ALRB procedure, gets two opportunities to prove that they did nothing wrong or that they're not liable. First, it has an opportunity to present witnesses, evidence, testimony, arguments before an administrative law judge. That ALJ then makes a decision. That decision is appealed then to the full labor board that has been appointed by Governor Brown in this case and confirmed by the Senate. That board will then make a decision. So by the time we're talking about an appeal to the courts, the employer has had two opportunities to prove that they did not do any wrong. So in fact, it's incorrect to say that they're being treated as guilty before innocent. They've now had two hearings, two processes to prove that they did nothing wrong, that they don't owe any money. So this is about the third process, the third appeal, requiring the posting of a bond. In due process, when these labor code provisions that already exist on the books, when they were challenged on that basis, the courts determined that because there was a hearing and the employer was allowed the opportunity to present evidence, there was no infringement of due process rights.
The suggestion that you're getting two bites of the apple with the ALJ and then you get a second go-around with the full board, I think there will be a number of people who have had an experience through this process where they may very well suggest that that's not in reality two bites, it's really one, that the kind of opportunities that they have within that procedure, within that process, is in some instances cast against them from the beginning. I'm not going to debate that. I just wanted to point out that this is within the ALJ and within the board hires the ALJ. And I appreciate your explanation. I want to take the next step to the difference in California with respect to the National Labor Relations Act that does not require the posting of a bond in order for an employer to appeal an NLRB decision. At least that's my understanding. Why should California deviate from that?
Thank you for that question, Mr. Patterson. As you know, in the 1930s, when the National Labor Relations Act was adopted, agricultural employers specifically lobbied the federal government to exclude agricultural workers because they said agricultural is so different. You can't have a law that applies to the rest of the workforce apply to farm workers. So based on that historical exclusion, which was based on issues of racism and economy, agricultural workers were excluded. So the fact that the NLRA has chosen to exclude this class of workers is the reason why we have the ALRA. Now, the ALRA itself has numerous differences that are unique to California and agriculture. One is that make-whole is not a statutory right under the NLRA. It was written in from the beginning because of this issue of ensuring that employers bargained with the union. Mandatory mediation is also a process that is not contained within the NLRA that is part of our statute. Employers under the NLRA can petition for an election. They cannot do so under the ALRA because the legislature determined that employers should have no role in that process. So I could go down and point numerous differences, but the fact of the matter is the federal government chose to exclude farm workers from the NLRA. So that salient fact, I think, is important to keep in mind as we try to address some of the problems that are posed by California agriculture.
But the choice, the exclusion, not utilizing a bond was a decision. I'm trying to figure out what the heck the connection is. This was about labor. This was about complaints. This was about the due process for both parties. And I'm trying to determine what is the reason and purpose to do something as has been outlined, which is interpose a bond, a expensive cash outlay, while the process is going forward to finally adjudicate a matter.
I think actually Mr. Brown talked about Labor Code 98.2, and the idea was to deter frivolous appeals and to deter delay, and that's really the purpose here. You want to deter frivolous appeals and delay, and the employers, we believe, will post bonds when they feel they have genuine issues that they feel the courts should decide, and will choose not to do so when they would only do so to delay or frustrate the process. And that's the real purpose, I think, that, at least from our perspective, why this bond requirement is important.
Yeah. Well, my bigger concern is that you basically short-circuit a fundamental principle to have an opportunity, as was, I think, previously outlined, to have a clean slate look prior to a final determination. I think that's just fundamental to fairness, but I suspect we disagree there. But one final question under the bill. The employer does have the ability to appeal to a higher court in case they lose the appeal to the ALRB, right?
Yes.
Okay. So I get that then maybe this is rhetorical, but the employer would pursue a higher appeal. Under this bill is going to have to pay out that bond money, right? Within this year-long compliance period, even if they pursue that higher legal action. Is that correct?
The way the bill is written is the employer would have a hearing before an ALJ or a lower judge, then would be able to appeal that decision to the ALRB. When the ALRB issues its final decision, then the employer generally has 30 days to seek an appeal with the courts of appeal. At that point, before filing its appeal, or as a condition of filing its appeal with the court, it would have to post the bond. So, did I answer your question?
Yeah. Okay. Thank you. Appreciate it.
Thank you. Any other questions or comments? Senator McCarty?
Thank you, Mr. Chair. I support this bill and this effort, and one, I think it would help bring expedited economic justice to farm workers, and secondly, while the bond issue is not an easy one, I think it will help ensure that at the end of the day, if it's needed, there's restitution, because many times some of these entities fold and move on, and so there's a process. It goes through a few hoops, and so it's not arbitrary. I think this is a reasonable effort, and I would move the bill.
Second.
Thank you, Senator McCarty. So the bill's been moved by Senator McCarty, seconded by Senator Lowe. Mr. Chu, did you have a question?
Thank you. I just wanted to thank Assemblymember Campos, a proud daughter of a farm worker, to always stand up for the farm workers. And I also wanted to thank many of the farm workers here. You're giving up a date of your pay to come over here and testify in front of us. Thank you very much for coming.
Thank you very much. Hearing and seeing no other questions or comments, we do have a motion. We do have a second. Ms. Campos, would you like to close?
Mr. Chair and members, I respectfully ask for your aye vote. I think it is timely for us to create a mechanism and a law that will make sure that we do not have any more ace tomato situations for the farm workers anymore.
Thank you very much, Ms. Campos. I appreciate you bringing this measure forward. As was noted by Mr. Martinez, this committee did hold an oversight hearing 5 years ago regarding the Ace Tomatoes case, and it's just appalling that this matter is still being litigated here today throughout these years. Clearly, there's been softer steps to understand and to mitigate this issue, but now we continue to find ourselves with this matter unresolved because there's structural problems with how these issues are dealt with. So in light of having taken softer steps, it is appropriate, as noted by Senator McCarty, that we do have to take appropriate and responsive, more aggressive steps to address this structural problem. So with that, thank you for bringing it forward. Really appreciate you standing up for our men and women that work so hard in the agricultural community. So with that, Madam Secretary, please call a vote.
Motion is due pass as amended to appropriations. Hernandez.
Aye.
Hernandez, aye. Harper. No. Harper, no. Chu.
Aye.
Chu, aye. Lowe.
Aye.
Lowe, aye. McCarty. Aye. McCarty, aye. Patterson. No. Patterson, no. Thurman. That bill is out.
Bill is out. Congratulations. Thank you. Thank you. Okay. Mr. Lowe, I think you're next with Assembly Bill 883 relating to employment and public employee status. Whenever you're ready, committee member.